Here are 3 secrets of offshore trusts that could save your financial future. First secret, offshore trusts, especially in places like the Cook Islands, offer legal protection that makes domestic trusts look like paper walls in a hurricane. Look at the case law. I've seen US-based asset protection trusts penetrated by results-oriented judges on a regular basis. I've been in the asset protection game setting up companies and trusts for 34 years, both offshore and domestically. Trust in the Cook Islands for nearly 30 years, and my firm and my law firm that I'm a CEO of has established more Cook Islands trusts than anyone on the planet. So why the Cook Islands? 3 big reasons. Let's break it down. Number 1, strict fraudulent conveyance laws with short statutes of limitations. In plain English, the Cook Islands protects your assets immediately. Plus, if somebody is foolish enough to claim that you moved money offshore to dodge them, and they try to file a claim, they've got a tiny window to prove it. Usually just 1 to 2 years in the Cook Islands, or their courts won't even hear the case. Compare that to the US, where states don't give instant protection, and they can give creditors 4 to 10 years to claw back assets. I had a client, a doctor from California, who got sued after a patient claimed malpractice. He'd set up a Cook Islands trust with us 2 years prior. The plaintiff's lawyer tried to crack it open, but that 1 to 2 year clock had already ticked out. Case closed, asset safe. Reason number 2 we choose the Cook Islands is high legal hurdles for foreign judgments. Let's say that you lose a lawsuit in the US. The winner can't just waltz over to your Cook Islands trust and demand your money. They have to relitigate the entire case there from the very beginning under Cook Islands law, which is stacked in favor of the trust. In fact, a 2022 study by the International Asset Protection Association found that fewer than 2% of foreign judgments succeeded in cracking Cook Islands trust. That's a 98% wall of defense. For the trust that we've set up, since we specialize it and we know what we're doing, I've never seen a client lose money from a judgment in a Cook Islands trust that our firm has established. And that's saying a lot since we've set up more than anybody. Number 3, the trustee is outside U.S. jurisdiction. Now here's where it gets fun. U.S. courts can bully a trustee in, say, Nevada to hand over assets, but try telling a licensed bonded trustee company in the Cook Islands, a tiny paradise 6,000 miles away, to comply. Good luck. And that's why I've never seen one of our trusts that we've set up penetrated by a judgment. In fact, I'll never forget a case where a creditor's attorney called and they talked to our Cook Islands trustee company demanding access. The trustee politely said, "Sorry, mate, your courts don't have authority in my jurisdiction," and he hung up. True story. So translation, even if somebody sues you here and wins, getting to your offshore trust is like trying to break into Fort Knox with a plastic spoon. And that's why after 34 years in this field, I tell clients, if you want real protection, go offshore, specifically the Cook Islands. And we've set up more trusts there than anybody in the world because it works. Secret number 2, you don't have to give up control to get this protection. And this is the best part. This is where people go, wait, I'm not handing my life savings to some stranger in a far-off land. And you don't have to. Here's how we do it at Asset Protection Planners. We put a Cook Islands LLC inside the Cook Islands Trust. And here's the kicker. You're the manager of the LLC. So picture this. You've got $2 million in the trust. Maybe it's cash, stock. You could also secure rental property with certain liens, put the proceeds in the offshore trust. Now that LLC owns those assets. And as the manager, you can invest, spend, move money around, invest in stock. So when the waters are calm, it's your yacht and you're the captain. But when the legal storm hits, say a lawsuit or creditor is breathing down your neck and a judge could order you to bring it back, the control shifts. Our licensed bonded trustee company law firm can step in as the manager of the LLC. That's better than having the judge in control that could take all of your assets. They've never taken a client's assets, and we've been setting up trust there, like I say, for 30 years. They take the wheel, lock everything down, and say, not today, folks. Now you can get the money out anytime you want to, but your enemy at law can't get it out, and that's the key thing. I have a Cook Islands trust for myself and my family. The trustee company is the only signatory on the account. That's the trust that I give the trustees there. So the separation is really what makes it bulletproof. In fact, the U.S. Supreme Court ruled in a 1997 case, Anderson versus Abbott, that if you're not in control during an attack, courts can't touch it. Smart, right? Let me give you an example. I know a lot of people like control, but if you have the control, then that means the judge has the control, not you, because they can order you to bring the money back. So that's why our licensed bonded law firm trustee can step in, the most highly regulated jurisdiction in the world for trusts. So here's an example. A client of ours, a small business owner from Texas, had a $1.5 million trust with us. That's how much money he had in it. He ran his LLC like normal, paid bills, bought equipment, and then a competitor sued over a contract dispute. And the second that lawsuit landed, our trustee stepped in as the LLC manager. The assets untouchable, and the competitor settled for pennies because they knew they'd never crack it. So that's the beauty of this setup. Control when you want it, protection when you need it. And the nice thing is you still have control, because you can just fire that trustee and hire another one. And no, this isn't some shady loophole. It's 100% legal, secured by pros like us who have been doing this for decades, nearly 30 years in the Cook Islands alone, and I've seen it work time and time again. So just for clarity, I've been in the asset protection business for 34 years, setting up Cook Islands Trust for 30 of those 34 years. Secret number 3, offshore trusts aren't just for the super rich. So there's this myth that you need Jeff Bezos level wealth to justify one. Nope, let's debunk it right now. At Lawyers Limited and Asset Protection Planners, we've set up trusts for clients protecting anywhere from $500,000 to $5 million or more. So think about it. This could be your retirement savings, equity in your home, or a family business. So according to a 2023 report from WealthX, over 60% of high net worth individuals use offshore strategies. Not billionaires, just folks with something worth protecting. So are you a doctor with millions in the bank, a real estate investor with a few properties, a business owner with a couple of million in revenue? This is for you. And here's the kicker. It's a preventative tool, not necessarily a last minute fix, even though it can work. This is, by the way, one of the few tools that will work after a lawsuit, but it's going to cost you more, and you're going to get a lot more scrutiny from the courts, even though it'll protect your assets. I had a client, a dentist from Florida, who set up a trust with us and put $700,000 into it in 2018. 2 years later, a patient sued him, and this lawsuit was for $2 million. Because he acted early, the trust was ironclad. If he waited until the lawsuit hit, it might be too late, especially in a divorce case where we can't even take the case after a divorce is filed because of the financial restraining order. So timing matters, so act early. Now, truthfully, offshore trusts do cost more than domestic ones. A basic U.S. asset protection trust might run you from $10,000 to $15,000 for a good one. A Cook Islands trust, you're looking at $20,000 to $30,000, depending on the extra bells and whistles that you need and the companies inside the trust, if you have real estate to protect and so on, plus the small annual fees. But here's the math. You've got $1 million plus at stake, and a lawsuit could wipe it out. So is 20 to 30 grand a fair price for peace of mind? I'd say so. It's like buying the best insurance policy on the planet. A funny story, a guy once told me, I'd rather spend that on a boat. And I said, go ahead, put the boat in the trust, and then nobody can take it. And we did some liens, equity stripping on the boat and so on. He laughed, but he did it. He set it up. So true asset protection isn't about hiding, it's about planning. Okay, now you're probably wondering, why do I keep harping on Cook Islands? So let's dig into that, because it's the gold standard and we've mastered it at Lawyers Limited and Asset Protection Planners. The Cook Islands passed the world's first asset protection trust law in 1989, and I started working setting up Cook Islands Trust shortly thereafter. And for nearly 30 years, I've watched it become the Fort Knox of trusts. Their laws are so tight that in 35 years, no foreign creditor has successfully pierced a properly structured Cook Islands trust. Zero. In fact, a 2019 legal review found that over 90% of challenges fail within the first 6 months due to procedural roadblocks. Here's a wild case. In 2005, a U.S. millionaire got hit with a $10 million judgment. His Cook Islands trust held $8 million. The creditor spent 3 years and millions in legal fees trying to break it. Flew to the islands, hired local lawyers, the works, and which was, by the way, a tough thing to do because in the Cook Islands, there's they can be conflicted out if they've worked with a trustee before, and pretty much all of the lawyers on the Cook Islands have worked with our trustee company law firm, and so they're conflicted out, so they can't represent an opponent. So they had to actually go to New Zealand and hire a lawyer from over there. So the bottom line result is they got nothing. Why? The trustee didn't budge. The laws held firm, and the statute of limitations ran out, preventing further filing. So that's the kind of muscle we're talking about in the Cook Islands. And at Asset Protection Planners, like I say, we've set up more of these than anybody else, thousands over 3 decades. So we pair that trust with the Cook Islands LLC, make you the manager, and keep our trustee ready to step in as the LLC manager when threats arise. It's a system we've perfected. Okay, so how do you know if an offshore trust is worth it? Here are my thoughts after 34 years in the trenches. Step 1, look at what you've got. Got $500,000 or more in savings, property, or business, you're a candidate. Step number 2, think about risks. Lawsuits are up 15% since 2010 for the American Bar Association. And if you're a high-risk professional, doctor, lawyer, entrepreneur, this is your shield. Step number 3, act early. The best time to set this up is before trouble starts. Real example, a contractor I work with had $3 million in assets. He set up a trust in 2020. Last year, a subcontractor sued him for $5 million over a botched job. He thought it was just a bogus lawsuit. Our trustee stepped in as the LLC manager, and his trust held firm. He's still in business. Prevention beats panic every time. So here's the bottom line. Offshore trusts, like the one we've mastered in the Cook Islands, give you stronger protection, legal control, and peace of mind, no matter what your net worth. So I'm the business guy, the CEO of the Lawyers Limited Law Firm, and after 34 years and thousands of trusts, I can tell you this works. Want to learn more? Go ahead and subscribe to my channel. We're dropping videos like this every week to help you protect what's yours. Drop a comment below. Visit us at assetprotectionplanners.com for more free information. Fill out a consultation form if you're serious and not just curious. And what's the one asset that you'd like to lock into your trust? I'll go ahead and see you in the next one. This is the Business Guy.